cause number 25 DCCR 0114. You're charged with engaging in organized criminal activity. Ms. Perazo has filed a motion to withdraw as your attorney. And so do you have any opposition to me allowing her to withdraw? Answer out loud. Okay. So Ms. Perazo, I will grant your motion. Mr. Jackson, do you have the funds to hire an attorney?
She's not working on it.
You're working on it? So here's what I'm going to do in the meantime because you're in custody. I'm going to go ahead and appoint an attorney. That way you have no lull in representation. Somebody will begin working on your case. If you get someone hired, then they can file appropriate motions to step in, okay? But you will be appointed an attorney today. Now, before I send you back to the jail, I want to talk to you about this stack of incident reports that I have of how you're behaving in our jail. And I know that one of the things that you wanted Ms. Perazo to do and that she had filed on your behalf that we're not going to take up today is for me to reduce your bond. And I can assure you nothing's going to happen other than your bond being increased if you continue to act like the little hooligan that you're acting like in our jail. I can't even tell you how angry this makes me. How old are you?
You turned 19.
Just turned 19. Well, let me tell you something. It is time to grow up. Because you and the other little 18, 19, whatever y'all are doing in there, you're never going to get out of jail. You're going to end up in prison, and your life is just going to be just like this. And is that what you want?
No.
It's not, is it? Cussing at the correctional officers, laying in bed because you don't want to get up, staying up late because you know when you get to sleep late? When you're at home because you're not in jail for violating the law. That's when you get to sleep late. That's when you get to make your own decisions. You don't get to make those decisions right now. And I get a report every single time you're acting up. And you're going to keep coming in front of me with another lawyer, and it's the same thing. The DA knows about these, and if you think that's going to make them want to be nice and offer you some great deal on your case, it's not. All it's going to make everybody want to do is something worse to you. So, starting today, if you think you want something good to come out of your case and you want some possible good treatment and to get out and to be able to live a life like the rest of us, start proving it starting today in jail. Otherwise, it's not going to happen. Do you understand? All right, go back with the bailiff.
Thank you, Your Honor.
Thank you. Mr. Kimler, you have Corey.
Judge, we discussed what I thought was going to be a solid agreement, and then after reviewing jail disciplinary, I just didn't think the court would approve it. So I up my offer, which is being refused.
Just to be clear, Your Honor, I had gotten Mr. Nichols to extend an offer of 4 years, which Mr. Carter was prepared to accept, and that's when I set it on the docket and made a plea. I was contacted by Mr. Nichols yesterday and advised that he was withdrawing that offer based upon the jail write-ups, which I've been provided with, and that the offer was now 6 years and with a 7-year gap, and Mr. Carter previously refused 5 years, so I did another refusal.
So, Mr. Carter, how old are you? 17 years old. And do you realize now what you acting up in jail has already cost you? Do you really? Tell me what it's cost you. Well, some of your life. But you had already talked about a deal in your case that sounds like you were going to accept. Is that right? And because you can't behave and follow the rules in jail, and I get those reports, and the district attorney's office gets those reports, and your attorney gets those reports, they decided you don't deserve that, and I don't disagree with them. So here's what happens now. If your case goes to trial, and I'm going to go through some things in a few minutes about that, and you get found guilty in that trial, that jury can also hear all of those reports, every last one of them. And if you think this man right here ain't going to bring those in and show that jury why you don't deserve any mercy or whatever, he's going to do it. I would if I were him. So if you're going to be in front of a jury, or you're going to be in front of the judge, or someone who's deciding what happens to your life, you might ought to change what you're doing in that jail. I just had a talk with another young one. I don't know what's going on in that dorm with all of you young ones, but what y'all all need to do is look at each other and say, I don't want to go to prison for a long time. If you do, you go act up over there. And man up and say, I'm not going to behave like that. Because you're a man now. And you're in felony court. You don't feel like a man. Your brain's probably not functioning like a man. But you are in felony court like every other grown-up man. And if you make kid decisions and think that horseplaying and treating the people that are trying to work there the way you are is going to get you anywhere, it will. It's going to get you in there longer. Does that make sense? So what you're charged with is the third-degree felony offense of deadly conduct discharging a firearm from October 13th of 2024. And what that means...
Judge, I'm sorry to interrupt again.
Yes.
He has a juvenile adjudication, which he is actually on parole for.
Felony conviction.
And that's a felony conviction. My understanding, and I need to file the proper notice, my understanding is that can be used to enhance him to a second degree. I don't think it precludes him from maybe getting probation from a jury. I need to make sure I vet that out through the family code.
Okay.
But my understanding is he's looking at a possible second-degree punishment range.
Do you agree with that?
It's a hybrid situation with the prior juvenile felony conviction. I think that Mr. Nichols is correct that it precludes, or it does not preclude him from having to be eligible for probation from a jury. However, it will enhance the punishment range from a third degree to a second degree.
So, Mr. Carter, what that means is that if you go to trial and a jury finds you guilty, and they find that that previous adjudication took place and was true, that you were adjudicated as a juvenile of a felony, that means that jury can sentence you anywhere in the range of punishment of a second-degree felony instead of a third, which is between 2 years and up to 20 years in prison. Do you understand? And I have a plea bargain rejection that you've signed with Mr. Kimler that shows that the district attorney's made an offer, if you wanted to enter a plea of guilty, for a 6-year term in prison or for a 7-year cap to me. You have every right to reject that offer and have... Yeah, go ahead, you have something to say?
You don't have to say that. I can just say it's just young, just being in jail, but at a young age, you're not really knowing that. No write-ups.
Yeah, but once you get several write-ups, the whole point of growing up is to learn from your mistakes. So if you keep getting write-ups, then you can't just say, I'm young and dumb, so I keep getting write-ups. I don't disagree that you're young and dumb, but this is ridiculous. I know our jail cannot wait for you to get out. Cannot wait. Mr. Coleman?
Yes, Your Honor, I'll be brief since I put everything, made the case position clear and I've sent some memorandum. I'd like to briefly shift the focus from the write-ups to the underlying facts in this case, which I believe are...
Stealing out of cop cars.
Stealing from patrol vehicles, at least 2 patrol units, Your Honor. Detective Matt Dixon is here if you want to hear more details of the detective. But Your Honor, I think the audacity, the boldness to steal these weapons from a police car goes to show what exactly the nature of this defendant is and what we're dealing with here. And even more than that, Judge, it appears from the underlying facts that the defendant may be implicated in a series of other car burglaries. We've got a Glock switch that converted one of those weapons into a fully automatic weapon. He was conspiring with another juvenile, a 16-year-old, to steal the weapons, which a photograph is attached to my sense of memorandum. If you've seen it, this was nothing less than an arsenal that these kids amassed, Judge. I shudder to think what could have become of these weapons if they would end up in the hands of other criminals, if they could have been used against law enforcement, Your Honor. Long gone are the days where there's a low-caliber Saturday night special that these kids use, in some type of crime. They are using, they are loaded for bear with fully automatic weapons. I'd ask the court to make an example out of this. He benefits from not having a criminal history to speak of, but Your Honor, this is beyond the pale. I ask you to send him, do 2 things, a split sentence in this case. Sentence him to prison for what he's done, and then following that, a consecutive probation period so that we can continue to monitor him and supervise him after he's released from prison. Thank you, Your Honor.
So, I wanted to make sure, Mr. Coleman, I've done this type of sentencing that you're asking for in some different cases. I think the probation period, if I sentence him to probation today, I don't know that I can make that consecutive. So I think
I believe you can, Judge, and if you need to recess this proceeding, I can get you case law in pretty short order. I think
because when would it start?
it will start after he finishes his period of incarceration.
Okay, so whatever I give him, if I do prison, and then I say it's consecutive with a probation, and does it matter if it's a straight or a,
I don't think so either, Judge. But again, I'm happy to get you some case law.
No, I appreciate the idea. Again, we've done it sometimes. What are you doing with all these?
In Texas, a judge
Not
can
sure.
Sir?
Not sure.
Not shooting people yet. What are you shooting? Why would you have these? What are you getting these to shoot at? Just to be tough and say you have guns? That's all that's happening with these guns on the street, is y'all are shooting at each other, at other people, at houses, at cars, at whatever. There's no reason to have these kind of guns. These aren't hunting guns, right? You're not going to shoot a deer. Do you hunt?
I do.
Do you?
Before,
Have you? Which one of these is your hunting gun?
none of those.
You thought you were pretty bad breaking into a cop's car, didn't you? That is some nerve. I mean, seriously, you're the second person I've had in 11 years that has had the nerve to do that. Here's what I'm gonna do, because I agree with Mr. Coleman. I would like, at least in the indecency case, to get treatment and probation on that case so that we know you're not gonna go make that type of bad decision again. But I'm not giving you probation on everything. You're gonna you wanna change your life and do better and not be young and dumb, you're gonna have some time to figure that out. So in cause number 24, DCCR 0389, I'm going to find that you entered your plea of guilty freely and voluntarily, find sufficient evidence to find you guilty, and at this time find you guilty of possession of a prohibited weapon. Mr. Coleman actually asked me to sentence you to 5 years. I don't think that's enough. I'm going to sentence you in that case to 7 years in the institutional division of the Texas Department of Corrections. You'll receive credit on that sentence for any time you've been in custody, and part of the reason I made it lengthier is because you have been in custody so long, and a 5-year sentence really isn't going to amount to much. Cause number 24, DCCR 0390, also find sufficient evidence to find you guilty, and at this time find you guilty of possession of a prohibited weapon. Sentence you to a term of 7 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. In cause number 24, DCCR 0391, find sufficient evidence to find you guilty, and at this time, find you guilty of the state jail felony offense of theft of a firearm. Sentence you to a term of 2 years in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. Then in cause number 24, DCCR 0392, find sufficient evidence to find you guilty. However, in that case, I'm going to defer all proceedings, place you on probation. No, that's a third. I'm going to find you guilty of that offense, sentence you to a term of 10 years in the institutional division, but I'm going to suspend that and place you on probation for 10 years.
Can I address the court on that? If it defers those with the registration, it would, if he did comply after he got out, that he may have a chance instead of a conviction.
He's already got 3 convictions,
I
so fourth.
understand that, but it's kind of,
May I respond, Judge? That is a reduced charge
I agree.
on that.
Can I give a straight on indecency though? Hold on. I think it has to be deferred. Hold on. Okay, so I'm going to go back in that cause number, which ends in 0392. find sufficient evidence to find you guilty. However, I'm going to defer all proceedings, and I'm going to place you on probation for 10 years. That will run consecutively to the other cases. So that probation does not start until you get out of prison. Then, if you violate that probation, you could be sentenced up to 10 years in that case.
And there it is, a young life hanging in the balance, decisions stacking faster than the clock can tick. Every action in that cell, every word spoken, is now part of the record, shaping a future that can't be erased. The law protects rights, yet it cannot shield someone from themselves. In the heart of the courtroom, we see a truth that echoes far beyond these walls. Maturity isn't given, it's earned. One choice, one moment of restraint, or one act of defiance can define the rest of a life. So, the question remains, when the lights fade and the doors close, will lessons be learned, or will history repeat itself once again?